EGM Network.
Hi, welcome to Silver Linings. I'm your host, Janine Barrows. Today, not this afternoon, in our studio, we have Raul Perez, who is a practicing attorney at Dill Evans in Rotaback. And we're going to learn a little bit with him today, not only about what drove him into the industry and specializing in the levels that he does, but also about preparation. So we're going to talk about preparation for wills and trusts and healthcare surrogates, and maybe the timeline we should consider when doing so. Before we jump into that, I just want to say good morning, Raul. Thank you for joining us.
Good morning, Janine. Thank you for having me.
Oh, absolutely. I am so excited about the next few weeks and what we're going to be bringing to our community. But before we even go into those things, I want to talk about you and what you bring to the table, not just for Silver Linings, but for our community and for your specific industry. So tell us a little bit about yourself, how you ended up getting into law and ended up where you're at now in the specialty areas that you practice.
Okay. Well, again, my name is Raul Perez. I've been a practicing attorney here in the area, specifically Sebastian, for 6 years now, and I have been an attorney for almost 10.
I didn't know it was that long.
Yes, I didn't either. And I work for Dill Evans and Rotaback, and I am the attorney who specializes in estate planning, probate administration, trust administration, and guardianships as well.
That's a lot of hats.
Yes, but thankfully it's all within the same scope of under elder law, so I'm able to manage it because honestly these different categories blend together, so it makes it easy to transition from one to another.
I like that. Okay, well, that means that the left knows what the right is doing. You guys are working together, left side, right side, your clients, all of those good things. One of the things that I have learned over the years working with our population in some sort of advocacy role or another is that people assume that, oh, I don't need things in order because everybody's healthy and we don't have any problems right now. And, I have a husband, he's going to make my choices, or my daughter, she'll handle it if something happens. And they fail to be prepared until there's an emergency, and then it's a rush to try and get things in order. And I imagine that you see that often as well.
Yes. Unfortunately, if you're at the stage where there is an emergency, there's not too much that can be done at that point if certain steps weren't taken.
So timing is a very important factor when we're preparing to age. Is that correct?
Yes. So I have a recent client who called in, and his wife is suffering through dementia. And now he wants to be able to make decisions for her regarding financial or healthcare or otherwise. And at this point, the wife can't competently sign a power of attorney or healthcare surrogate. So now it's too late. And now you have to go through the guardianship route. And at that point, it's going to take some time to get through the guardianship. More things have to occur than just a simple meeting and an execution of maybe a handful of documents and a meeting with an attorney.
Okay. And so that highlights a fallacy that I hear a lot about. Oh, we're married. My husband has the rights for this, or my spouse has the ability to make those choices and decisions for us. Is that the case? And what are the hiccups with that kind of thinking?
Well, so let's say that, and this happens, not always, but it looks like it's happening more often. If the wife has a bank account and the husband is not on it whatsoever, the bank is not just gonna say, okay, you're the husband, you get to make decisions about things that happen in this account. That's why you need a power of attorney. It's a way to assure that you're not going to have problems when trying to access certain things through certain institutions. I've had a client who couldn't access a long-term care policy, even though he was a spouse and they were together for 40 years. They needed a power of attorney. The wife couldn't execute one. She was, she just couldn't.
Capacity was beyond.
She didn't have capacity. And he had to go through the guardianship. Where if we would have met, a few months ago or a few years ago, then we could have had a simple 2-hour meeting where we could have discussed what they wanted, not just for their power of attorney, healthcare surrogate, but what do they want to do with their will, if they want to trust. And that encounter, we would have got everything done, got everything executed, instead of waiting to the very end and now finding out, okay, now we need to go the hard route. We need to go through guardianship.
And meanwhile, that takes time. It's not as simple as those 1 or 2 hours as you're mentioning. I hear a lot of people say, oh, I don't need that. I'll wait. My spouse can do it. My family can do it. But we know that there are barriers to simply making a verbal choice and actually getting it to fruition when an emergent situation comes into play. And you mentioned timing. Timing is very important. If we wait to the last moment, then we find ourselves in bigger predicaments. And I can't imagine what that spouse is going through while he waits for a guardian process, and he still needs to address ongoing issues to his day-to-day while caring for his loved one or helping to manage that care for them. So people don't realize that we should be proactive in our aging, in our planning process for that. What in general is the number one mistake made by your client base that you see when they come in to talk about services and needs?
Well, when they come in to talk to services, they're already far ahead of maybe what most people would think, right? They're trying to address maybe not a mistake, but they're taking their time to focus on planning, which is very important. Like I mentioned, what I normally do is we send our clients an estate planning questionnaire. Mm-hmm. We ask them, please provide your marital status. Please give me the name of your children. Let me know who you would want to be in charge of your financing, who you would want to be in charge of your health. Please provide me with the list of assets, bank accounts, IRAs, pensions, real estate, insurance. I try to get as much as I possibly can before we go into that meeting so that I can flip through my estate planning questionnaire and say, okay, let's talk about this. Your bank accounts, they're joint. Okay, great. So if you're married and one of you passes, then it goes to the other. Great. You did a small amount of estate planning there because on the first one of you to pass, you don't have to worry about estate planning.
Right. The other one will be able to pay the bills still and take
Right.
care of funeral services and things like that.
And they have access, right?
Mm-hmm.
That's also an important factor. Sometimes maybe I have a single person whose husband or wife passed away, and maybe they have a joint owner on the account. Okay, that's good because that will help you pay your bills. But do you know that that joint owner, once you pass, will be entitled to those funds? And was that your intent? Or did you want to give that to maybe your 3 children? Or did you want to give that money to your grandchildren? Or did you want to leave that to charity? So those are the type of things that once I have the information, and some people don't, not that they don't intentionally know, but it's not things that they normally explain to you when you go down to a bank and you open an account. Or when you have multiple accounts, you just don't think that deeply. This is my account. I'm going to use it for my business, or I'm going to use it for my rental properties, or I'm going to use it as my expenses or savings. It's yours. You have access to it. You don't go further than that sometimes because there's no need. You're not planning for your passing. You're planning for your life.
Right. I bet it's not a topic that they think about. And I imagine that, no, many of the bankers don't have those conversations. But you don't want to make that preemptive strike either, some people, because of the reality of that depth of importance of our death and our mortality. So a lot of people shy from that.
Well, and that's probably why it's hard to come into an attorney's office, because once you say, okay, I'm going to talk about estate planning, you're picturing what's going to happen close to your passing or at the time of your passing. And it's not, most people want to talk about.
No, we still have our planning for our will, and we just kind of look, and then we like, and that, so yeah, I understand that thoroughly, because we don't want to look at that of, oh, it's going to happen to us. So we only want to address it if it's going to happen, as if it may never happen. And so I can imagine what you do encounter like that. You know, that brings up, and you brought up many things in that conversation, and you talked about your trust, your assets, your will, your healthcare surrogacy, your power of attorney over your medical as well as your financial. There's a lot of important aspects in those documents and being prepared with them. But can they all be done at once? Should some be done before others? Is there a timeline that the average Joe should consider if they wake up and go, you know, aha, today is the day I'm going to get my ducks in a row because I don't want somebody else to have to corral them and get the information in a difficult way. So what would you say?
I can't say if there's a certain time to get it done. I mean, in reality, probably to have one done as soon as you can so that you have something there in case of emergencies. I mean, unfortunately, I have stories of clients calling, 35 years old. I mean, who needs estate planning at 35 years old? But their significant other, they weren't married. That person has no right to make any decisions over that person. Now they're in a hospital bed, an aneurysm, or any other issue. And now what do? I mean, even if you wanted to start a guardianship, you're a significant other. Normally there's procedures that go along with guardian and who should be appointed in those circumstances. What happens if there's family members who don't like that significant other?
And that happens, yep, more often than people think. Hold that thought, Raul. We're going to take a small break because we do have commercial sponsors and show sponsors, and I want to give them a moment. So hold on to that thought. We'll be right back after this commercial.
My name is Mike Conway, and I'm with Royal Fund Management. We want to revolutionize your workplace retirement system. The recent Secure Act 2.0 legislation has opened the door for pooled employer plans, better known as PEPs. Learn how a PEP can revolutionize your 401k. Call me, Mike Conway, today. I'll give you a free benchmark of your current plan or set up a new plan. Visit secureact2info.com. That's SecureAct, the number 2, info.com.
Investment advisor representative of Investment Services offered through Royal Fund Management LLC, an SEC registered advisor. 401k maneuvers and other business for Royal Fund Management.
Get stoked, bro. It's the Downtown Beach Bash presented by GHO Homes. Catch the wave of fun and ride it all the way to downtown Vero Beach for this gnarly free street party with live music by Riptide, plus kids games, beer, food trucks, and prizes. We're not hanging 10, bro. We're hanging from 6 to 9 p.m. Admission is free. Sponsored by GHO Homes and Millennium Cremation Service. The Downtown Beach Bash, a Main Street Vero Beach event. Friday, March 28th, 6 p.m. Downtown Vero Beach.
Welcome back to Silver Linings. I am so grateful for our commercial sponsors and even more so for our show sponsors. So I would be remiss if I didn't give a shout out to the legal team at Rooney and Rooney here in Vero Beach and to the financial team over at Conway Financial Planning. I assure you, if you have a need and a question, they have an answer. On that note, Raul and I were talking before we went to break about putting our ducks in a row in somewhat of a timely manner and how it's very hard to determine what that timely manner is. It could be through natural aging and just through life challenges that come organically to us on a long-term scale, or it could be an unexpected tragedy that could alter people's lives at a young age and force them into a position to have to get legal attention and assistance to put those things in order as best that they can after the fact. And that's not always a potential solution. Sometimes it just brings into the reality that you can't do it at that time because of parameters. It's not going to always be smooth. And the attorneys are there to help make it as smooth as possible. So, Raul, you were saying that, yes, tragedy could strike at any time, and you could find yourself maybe not even being in a married role and having to be stepping up to speak on behalf of your loved one or your friend or your partner or your neighbor or your aunt or the individual that you care about that you're bringing this topic to and about. And that is a hard reality for many people. Because most of us, like we were saying earlier, we don't recognize that it's not an if, but when it's a when. We think, oh, life is running very smoothly today, And so we don't have to do that because that happened to somebody else. And we'll do it eventually when we need to get it done. So with that, what is the benefit of if you are a married person and you have children? And what is the benefit of setting up a power of attorney for you as a family in preparation versus not doing it for them as a family? So as children and support structures are addressing a tragedy or a problem, what is it like for them if mom has prepared versus if mom has not prepared?
So if mom has prepared, what she can do, even if she is married, we would set up a power of attorney, healthcare surrogate. Normally, the spouse will pick their their spouse to be the first one in charge. Sometimes clients don't come back and say, well, I'm going to make a change after my spouse passes away. So if we plan accordingly, what we can do is we can put the spouse as the first person who's going to act. And if that person should predecease the principal, then we can have a child or a friend or whoever they want as a secondary.
As a secondary option, because life changes even for the people we put in place, right?
Correct. And we can even add a third or a fourth. I mean, I always recommend to my clients to have at least 2 people on the power of attorney and their healthcare surrogate, and even in their wills or their trust, have 2 people who can serve as personal representative or trustee, just in case someone passes away. You have someone there who can go ahead and take the charge. If you have a third, I strongly recommend that as well. That way there are options, right? You don't, in some situations, some people that you pick just can't handle it for whatever reason. They have their own. It can
be intense for some individuals, whether it's emotional, time-wise, or knowledge structure.
Yes, and there are a lot of people who live here who have families long distance. So, something happens to dad, now son's in charge, but they live in Washington State. But we have a daughter who lives in Jacksonville. Well, maybe in that scenario, the son doesn't, need to do it, or there's an alternative. And if we have them all listed within the power of attorney and healthcare surrogate, then they can take the charge at that point, make things easier for the family as a whole.
Right, because normally those documents don't get enacted unless there's some kind of trauma or cognizant issue that precedes the individual, the client, from being able to make those own choices on their self. So it's usually an emotional time for the entire family.
Yes. And just to point out, for example, there are many different powers of attorney, right? You can have a general power of attorney, limited power of attorney. The ones we draft normally are durable power of attorneys. And that is important because the moment you execute that power of attorney, it becomes active. So yes, you are the person who gets to make the decision as to what you do. But if you give that power of attorney to any agent, they can step in and they can start taking actions if they have a copy and they present that. So I'm very cautious when I talk to my clients about powers of attorney, make sure they have someone who is trustworthy. I normally will tell them to keep it with them unless it's absolutely necessary to give it away, possibly inform their agent as to where it is and where to get it if something happens, because, it can be misused.
And the power attorney has to have, you mentioned, actually physically has the paperwork with them, right?
Yes.
To submit.
Yes. And a copy is as good as an original. That's enforceable. So if they have a copy, then that's good enough.
And it's the newest date that actually takes precedence if there are multiples, right?
Yes. So it's the most present in time. So if you have one 5 years ago and you do one this year, this is the one that's active. However, who's going to know that?
Right.
So if you give your power of attorney to a bank,
whoever arrives with it that will be able to utilize it. So it is wise to be proactive. Now, say mom didn't prepare and didn't have 1, 2, or 3 potential individuals lined up should somebody pass away or somebody need to be closer in proximity to make those choices. And now you have a child in a situation where they're making decisions. What does that look like for them? And are they capable of making and helpful decisions for their loved one if they don't have things in place?
So if there is no type of documents in place and a spouse passes and the surviving spouse has children who can help, as long as that spouse is able to make their own decisions, then I normally encourage them to talk to their family to, help out in any way they can. If they don't have documents, that's the perfect time to talk to an attorney to go ahead and create those documents. And unfortunately, if they don't do anything and I get a call from a son with that mother who is now suffering from some form of memory issues or something along those lines, then I would ask the son, to put me in contact with the mother if there's still a chance that maybe it's something small. Maybe it's just a small lapse in memory. It's not something that is a cognitive impairment like dementia and Alzheimer's, and it's possible that we can speak, and if she knows what she wants and she wants to make sure that her son is power of attorney and I feel comfortable with her capacity, then we can execute that document. It's more than just black and white when it comes to capacity. And that's why, if there's a chance to be able to simplify things with doing a power of attorney and that person has the capacity to know what they're signing, then let's see if we can get that done before we have to turn to a guardianship.
So if you aren't able to, it is a guardianship. And I want to hold that thought. I want to say something that I found was interesting is that capacity is determined by the attorney at the time, correct? Unless there's been vast documentation of a diagnosis.
So when we talk about capacity, we talk about legal capacity.
Mm-hmm.
And the only person who can determine what legal capacity is a judge. I can get letters from doctors who will tell me that this patient has dementia and Alzheimer's or memory issues, but that is not definitive. So I can still decide myself to interview this person and determine what I believe their capacity is and make a determination for myself if I think they have the sufficient capacity to understand what they're signing. Obviously, if there are medical records that I am presented with, then the likelihood is they're not going to have the sufficient capacity,
Right.
and I'll have to recommend other alternatives.
Right. So that points out a few things for me. One, you have to be very compassionate in your role because there's a lot of people that are prepared and those that aren't, or maybe have preparation that isn't actually lined up with what's available at the time of their need. So you have to be empathetic. You have to think ahead of the game, what they might need in the future versus what they're looking at and so forth. You have a very personal and intimate relationship with your clients and their families, because you are placed in a very trustworthy role for them to help them be prepared. So we could talk all day long in reference to how to be prepared in the different documents. And I would love to go in depth of that because it comes up over and over when I'm working with families and I see it. But before we wrap up today, I want to know, why did you go into law? What was the driving factor for you? And what is the most favorite aspect of your role?
Well, the real reason is because I couldn't become a professional baseball player. But other than that, no, I remember there was I can't remember exactly when, but I must have been in my teens, and my mom got in a really bad car accident. She had to be flown to the hospital in a helicopter.
Oh, wow.
And it was just a very traumatic time.
Yeah.
And thankfully, she suffered injuries, but she's still around. She's still walking, talking. She's still doing everything she can. She's great. But when I saw that, I said, okay, I think I want to move into a role where I can help people, and how can I best do that? And that's when I said, being an attorney is the best way to do that.
Right, because really a lot of things boil down to the law. It boils down to the law and the legal system and being prepared for your own decisions. Raul, I'm so excited about the next several weeks and sitting down with you and working with you and learning more about our communities and the silver linings that exist within it. I just thank you for your time today. Thank you for the education, and we are looking forward to growing together with Silver Linings. Before we go, please, if you have questions, reach out to Raul directly. You can find his contact information on their website, which is going to be, say it?
dillevans.com.
Excellent. And until then, we'll see you next week. We hope you have a fabulous day.